Tension escalates once again as Nnamdi Kanu's American counsel, Brisbane, has reportedly filed a fresh petition at the International Criminal Court (ICC), demanding a formal investigation into alleged human rights abuses by the Nigerian federal government. This comes shortly after Brisbane's recent letter to Justice James Omotosho raising concerns about the handling of Kanu's ongoing trial, including claims of political interference and denial of fair trial rights. International eyes are now focused on Nigeria like never before. So guys, let's break it down. Welcome back to Prospect Channel TV. Thank you for always coming out here. God bless you all. Amen. So my people, you don't read for Abuja. Sources close to the ICC talk say the fresh petition don't land serious wahala for Nigeria. According to the document, Bruce Fem, they demand investigation into alleged torture, unlawful detention, and attempts to sabotage Kanu's defense, especially after he sacked his legal team and chose to defend himself. So one insider for Aso Rock talk say, we never expect this level of international pressure. The ICC don't start, they look everything, and this fit affect top government officials. Bruce Fem allegedly highlights the letter he wrote to Justice James Omotosho, insisting that the Nigerian court cannot ignore fundamental human rights. The petition reportedly calls for ICC to monitor Kanu's next court section closely and ensure his safety and fair trial. So social media, they burst with reactions. Finally, word they watch the federal government. Federal government no fit play with fire this time. Chinedu Okoye. Another person talk say if anything happen to Kanu, international sanctions no go delay. This is coming from Rebecca Summit, Washington DC. Analysts talk say this fresh ICC petition fit trigger serious diplomatic consequences for Nigeria, especially as international bodies they watch closely. Human rights advocates warn. This na major test for Nigeria democracy. Kanu's case they show how political interests they clash with human rights obligations. Meanwhile, Aso Rock insiders they reportedly discussed strategies to calm global backlash, including briefing diplomats and releasing official statements promising due processes for Kanu. Meanwhile, Nnamdi Kanu, in a suit filed before the Federal High Court in Abuja, is seeking to nullify the terrorism charges against him and permanently stop all further proceedings in his ongoing trial. So, in a written address supporting a preliminary objection, Kanu argued that his continued persecution under a repealed law and based on a disputed prescription order violates the Constitution, the African Charter on Human and People's Rights, and Biden appellate decisions. The IPOB leader, through his counsel, seek 7 key declarations and orders, including that his trial under the repealed law, that is expired law, Prevention Amendment Act 2013, and based on an ex parte prosecution order obtained without a fair hearing, is unconstitutional, null and void. That the Federal High Court's 2017 order prescribing IPOB obtained while Justice Binta Enyako's ruling that IPOB is not an unlawful society was still in force, is unlawful and cannot form the basis of criminal liability. That the extraordinary rendition of the defendant from Kenya, that is Mazi Nnamdi Kanu, without extradition proceedings, stripped the court of jurisdiction to try him. That his prosecution violates his right to a fair hearing and confidential communication with counsel as the Department of State Service, the DSS, allegedly monitors his meetings with his lawyers and sees legal documents. The Court 1 to 8 of the Amendment 15 count charge filed in January 2022 constitute double jeopardy, having the same factual basis as counts previously struck out in April 2022. Kanu argued that since the Terrorism Prevention and Prohibition Act 2022 expired, the 2011 and 2013 versions of the law on May 12, 2022, all terrorism counts filed against him under the expired status are sanitarily dead. So he cited section 98 3 in brackets of the 2022 Act and section 122 2A in brackets of the Evidence Act, which required courts to take judiciary notice of repaired status. From 12 May 2022, the 2011-2013 regime ceased to have legal effect. Consequently, all terrorism counts framed under the expired 2013 Act, the void and incapable of founding any prosecution, stated. So Kanu also noted that one of the charges is laid under the Customs and Exercise Management Act, (CIMA), which was repealed by the Nigerian Customs Service Act 2023, rendering that courts counts constitutionally incompetent. He further argued that his forcibly abduction from Kenya in June 2021 without any formal extradition processes was a validation of the Extradition Act, the Kenya Constitution, and international law. Citing the Court of Appeal judgment of October 13, 2022, which discharged him and prohibited for further trial, Kanu maintained that by reason of his extraordinary rendition, the lower court, or indeed any court in this country, is divested of jurisdiction. A prosecution may not lawfully continue when the state is incompetent of abiding applicant discharge order. He added, referencing cases including military governor of Lagos State versus Ojukwu 1986 and Madukalo versus Nkendelim 1962. So Kanu recalled that despite the applicant court discharge order, he remained in DSS custody for 8 days before the government sought a stay of execution, an act his lawyers described as continuing contempt. He also accused the DSS of eavesdropping on his confidential Anthony client's communications, confiscating legal materials, and denying him on monitored meetings with his lawyers. Branches, he said, violate section 36B 6BD of the Constitution and Article 7, 1C of the African Chapter. So, guys, this is what Mazi Nnamdi Kanu is saying. He said they should stop that judgment on 20th because the court no fit pronounce judgment because of waiting on day before now. So, to permit a trial under expired law will render the legislative repeal meaningless and supplant preliminary authority with executive flat, he warned. So, my people, this is what is happening right now. So, as Nnamdi Kanu case continues, the states are higher than ever with this fresh ICC petition force the Nigeria government to respect human rights, or with this Mazi Nnamdi Kanu asking the court to stop this November 20th judgment. Will he ever change anything? So my people, we go dey give you all the updates as the story dey unfold. Remember to like, abeg share and subscribe for full coverage anytime from now. Thank you and bye for now.